And welcome back, listeners. Thank you for joining us for another episode of the Invisible Threat Podcast. And I'm very excited about bringing in my esteemed co-host, and I'm so thankful that they are my co-hosts, Dr. Matt and Joanne Eby, coming in from their new home again in Las Vegas, Nevada, just outside, I think, actually Las Vegas. But I'm really excited about the direction that we're headed. And this is the part that I know, as we gotten to know each other throughout the years, this is kind of sort of how we started our relationship in the first place, right? So anyway, I want to welcome in Dr. Matt and Joanne Eby. Dr. Matt, how you doing, bud?
Doing great, Carter, and you're absolutely correct. We started off on the sell side into the buy side, where we're working now and talking to the grantors, or the wealth owners, the wealth creators, and their advisors. So, and that's where we started from the very beginning, and the way that you have built in such a great job in building out Epic Services Company to work with advisors and the grantors, the wealth creators. So it's just been a fantastic 5 years watching, or 7 years watching you do all this work. And so now it's our honor to move over and start to use some of these tools and these ideas with the wealth creators and helping them identify what selection criteria to select a trustee. That's where we're starting today.
Yeah. So today, as we jump on into it, then we're really beginning a new series called Before You Select a Trustee. Right now, we're talking about a trustee / successor trustee, and we're beginning before the trustee has actually been selected, and probably at the point before you have even decided whether or not you need one. Right, Dr. Matt?
Yeah, Carter, because that's the first question many people face when, they've built wealth over the years, and they face this when they're creating or reviewing the concept of an estate plan. Should I leave the wealth directly, or transfer the wealth directly to the people that I care about, their family, their children, grandchildren, etc., or should I place it into a trust?
And when we say place it into a trust, Carter, the very common approach is for the wealth creator to create a revocable trust and put their assets into it. And that revocable trust will help avoid probate and so on and so forth. And it's extremely common that the grantor will be their own trustee for that revocable trust. And what we're talking about is who they're going to name in that revocable trust if they want to leave assets in the trust, and who will be, as you had said, Carter, that successor trustee. So regarding whether or not a wealth creator wants to transfer assets and leave them in trust, there are many reasons for the grantor, the wealth creator, to consider a trust. The beneficiary may be young, or they may have difficulty managing money. There might be concerns about creditors, divorce, taxes, government benefits, addiction, family conflict, or preserving wealth for future generations. And those sorts of considerations matter. But beneath all of them is another question that often remains unspoken.
Yeah, I mean, and this is really what we're talking about at the very heart of it. Like, if you're going to leave assets in trust, who should have that authority over the wealth, right? Who will determine how it will be best used?
And if the wealthy individual gives their money directly to the beneficiary, it's the beneficiary who makes that determination. But if they place it in a trust, some of the authority, or maybe all of the authority, is then transferred or given to the trustee. And it's the trust document, the trust instrument, that may make the authority visible. But it may tell you very little about the judgment that will govern how that authority is exercised. That is the invisible threat. At the center of this series that we're started down at the beginning of this process about how you select a trustee.
Yeah, so let me go ahead and start with the most basic objection. I see this I hear this all the time throughout the advisor network that we cater to. So if I have raised capable children and know the people I want to benefit from my wealth, why not just simply give them the money outright? Why create another structure, another cost, right? Potentially, and another person who can stand between my beneficiaries and their inheritance?
And I totally agree with them. That may be exactly the right choice. That may be exactly the right answer for a given family. An outright inheritance may respect that beneficiary's maturity, their independence, and the ability to govern his or her own life. But we should understand what accompanies that transfer of money. An outright inheritance does not merely transfer assets. It transfers authority and the responsibility to manage those assets appropriately. The beneficiary is the one who decides whether to spend, save, invest, give, start a business, buy a house, or preserve that wealth for the next generation.
And for many families, that is precisely the intention. The estate plan says, in effect, this is now yours. I trust you to decide. And there's nothing careless about that conclusion.
Yeah, and that's a great point, Joanne. So an outright inheritance or an outright distribution is not the absence of planning, right?
That's correct. That can be a deliberate judgment that the grantor believes the beneficiary, the intended beneficiary, should receive both the wealth and the authority over it to decide what to do with it.
However, the reverse is also true. Creating a trust is not automatically the mark of careful planning. A trust may be technically sophisticated and still allocate authority poorly. It may contain pages and pages of detailed provisions and place enormous discretion in someone whose judgment the grantor never examined. The legal structure of the trust document absolutely matters, but the structure does not answer the human question. Who should be trusted to exercise discretion?
People may not think of an inheritance as a transfer of authority. They think of it as a transfer of property, but it really is the transfer of the authority of someone's wealth.
Yeah, and it's both, really, right, Carter? Because ownership of property carries choices and responsibility. Let's have an example. Suppose your daughter inherits $1 million outright from you as a parent. When you pass, she may use $150,000 of that to start a business. Maybe you would be really proud of her. Or invest it conservatively, pay off her mortgage, or help her brother, or spend more than you might like her to spend that you might consider not to be very wise. But those are no longer your choices. Authority follows the money.
Now, suppose the same $1 million is placed in a discretionary trust for the benefit of your daughter. Now, that daughter may still benefit from the money, but if she requests $150,000 of the trust property to start a business, it would be someone else, the named successor trustee, who must decide whether the trust should support the daughter's request and then agree to the distribution of $150,000 out of the trust.
Yeah, so the same daughter, the same business, the same amount, but a different person is actually making the judgment on that.
Yeah, it's no longer the daughter making the determination, it's the trustee. If the inheritance is outright, the daughter would ask herself, should I do this? Because she has the authority. If it's held in trust, the trustee would have to answer, should the trust support this? And that's what we've been saying all along. Before asking whether the trustee should be a family member, which is what we've talked about all along, or a corporation, the wealth owner must decide whether someone other than the beneficiary should be answering questions like that at all.
And I love, about the authority, right? Can or should, as we get into this. And this brings us back to a distinction we have used throughout the Invisible Threat podcast, right? Can the trustee? That's what the authority is asking. Now, discretion asks, should the trustee?
The attorney who is doing the estate planning can draft the trust document to define what the trustee is permitted to do. And the document may identify the beneficiaries, distribution standards, purposes, limitations, and procedures. That is the architecture of authority. But when the trust document permits more than one reasonable path, the trustee must use their discretion in place of the original grantor's judgment to determine which path to take.
Let's return to the business request. Assume the trust permits the distribution for the daughter's business. That answers the first part. Can the trustee provide $150,000? And the answer is yes. It does not, however, answer whether the trustee should. The trustee may consider the daughter's experience in running the business. Take a look at the business plan, the amount of her own money she should put into and put at risk, the consequences of failure of the business, her other financial resources, the interests of the other trust beneficiaries, if there are any, whether current or future beneficiaries, and what the grantor hoped and intended the trust would accomplish.
Yeah, we talk about this a lot at Epic as we, educate advisors around the grantor's intent. And this is perfectly in alignment with that. And two experienced and competent trustees could consider the same facts and disagree on what the grantor's intent is if it's just about that authority. Is that right, Dr. Matt?
Absolutely. And the purpose of the trust. One might see a credible opportunity for the daughter's independence and future income potential by investing in the business. Another might see a risk that the trust should simply not finance. That disagreement does not necessarily mean either trustee is careless. It means that authority under the trust document, the can we question, does not make the final decision on the matter. The trustee's judgment, the should we question, has the final say.
Couldn't a very detailed trust document solve that problem? I mean, if I'm worried about how a trustee will act, why not say exactly what you want the trustee, or what they should do anyway?
Carter, I'll handle that question. A thoughtful trust document can actually do a great deal. It can define purposes, establish standards, limit authority, require consultation on requests, divide responsibilities, give beneficiaries rights, and also provide for removal and replacement of a successor trustee. But those details will still have their limits.
Because the future refuses to arrive in the form that we predicted. The grantor may imagine education as college tuition, but the beneficiary may propose an apprenticeship for her business adventure. The grantor may imagine housing as a first home, but the beneficiary may need replacement accessible housing after an injury. The grantor may imagine equal treatment among children, but one child may become a caregiver, foregoing higher income to help others, while another becomes independently financially successful. The beneficiary's life will not fit neatly into a list written 20 or 30 years earlier.
Just as you were like going through that, we try to have this proverbial crystal ball whenever I know that we're creating the trust documents on the front end, right? With our entire process. So more instructions in a trust document, though, do not necessarily mean less judgment. Is that fair to say?
That's correct, Carter. The written instructions can guide and also constrain judgment. But those written instructions cannot eliminate every future ambiguity or every need for the exercise of discretion.
The document can carry the grantor's voice forward, but it cannot carry the grantor's mind forward. The trustee will encounter facts the grantor never knew, choices the grantor never considered, and beneficiaries who have changed in ways the grantor never saw or even considered. The challenge is not to eliminate discretion. It is to decide where discretion should reside and to examine how it is likely to be exercised.
Yeah, that sounds like the point at which trustee selection normally begins, right? The client compares a family member, historically speaking, right? Most successful son or favorite daughter, whatever the case may be, with the option of a corporate trustee.
And look at what the client can readily learn. A corporate trustee can describe its fees, financial strength, investment services, technology, experience, and geographic reach. A family member can point to the years of trustworthiness that the family has experienced together, the shared family history, and individual knowledge of the beneficiary. And those things matter, but none of them shows the grantor how either candidate will exercise discretion as trustee of the trust once the grantor relinquishes control.
Yeah, I'm in their mind. I'm sure they've got it all figured out. But then let me ask this. Then what would the grantor need to see to determine who to select as a successor trustee?
Carter, how the prospective successor trustee interprets the purpose of the trust is really what the grantor wants to understand. What information would that trustee gather before acting? How would the trustee weigh present benefit against long-term preservation of the trust assets? How the trustee would distinguish support from dependency on the trust? How the trustee would respond to family pressure? How they would handle reasonable disagreement? And how they would explain and document a difficult yes or no decision.
And that is the missing evidence for the grantor. The grantor may be transferring authority over millions of dollars without ever seeing or knowing how the proposed trustee connects the language of the document to the beneficiary's actual life. The grantor sees the résumé. The grantor sees the institution. The grantor sees the trust document. But judgment that will connect them may remain invisible, and usually does.
We can see that in real life cases all the time. And that's different from asking, do you have good judgment, right?
Very different. Who would say no to that question if you ask somebody, do you have good judgment? The better request from the grantor to the successor trustee is, show me. Provide the evidence of how you exercise discretion. Walk me through a situation in which the document permits more than one reasonable answer. Show me what you would ask, what you would consider, where disagreement might arise, and how you would reach and explain a conclusion. The objective is not a promise of perfect judgment. It is to provide the grantor with meaningful visibility into the process. what influences the judgment, and reasoning that will govern the authority being transferred.
So most conversations about trust use the word protection. Protection from creditors and predators, as we call them, right? Divorce, overspending, spendthrifts, addiction, or loss of government benefits. Really important to consider. Isn't that the reason to use a trust?
Well, absolutely, Carter. And often protection is an important reason to establish a trust in the first place. But protection can become too general to guide the grantor's plan. Things to consider may include protection from what and for how long? Protection at what cost to the beneficiary's independence? And who is to decide when protection is helping and when it is harming?
A parent may say, I want to protect my son. That could mean protecting him from a creditor or an addiction, inexperience, or simply choices that the parent would not make. Those purposes are not interchangeable.
And they do not require the same trust or the same exercise of discretion. If the concern is temporary inexperience, for example, a beneficiary is a minor, authority might shift as the beneficiary ages and matures. If the concern is creditor protection, the trust may continue even when the beneficiary is mature and fully capable. If the concern is addiction, the trustee may face very painful questions about treatment, housing, and situations when providing money would end up doing more harm than good. Protection essentially begins the inquiry. It does not finish it.
Great point, Joanne. And from the beneficiary's perspective, protection may feel like control, like they're being controlled, right?
It absolutely does, and more times than not. A trust may express care and foresight. It may also require an adult beneficiary to explain personal choices to the trustee, disclose their finances, complete a budget, wait for an answer, or accept the denial. That does not make the trust wrong. It means the limitation of the beneficiary's authority should be deliberate, and the judgment imposed in its place should be examined.
And this is an important, right? As we work throughout the entire advisor network from sea to shining sea, what should the advisor and estate planning attorney do differently?
Well, Carter, they already help clients identify goals, risks, tax considerations, family circumstances, and legal structures. The additional opportunity is to make the transfer of authority explicit. Don't stop at explaining what a trust protects or how a trust operates. Instead, ask which future choices should belong to the beneficiary and which choices should belong to someone else.
And wherever the answer is, the trustee should decide, make the required judgment visible. Will the trustee balance current benefit against long-term preservation? Assess maturity, need, fairness, risk, or family circumstances. Resist pressure. Distinguish a different priority from irresponsible conduct. Those questions reveal what the client is really selecting.
Yeah. Assessing maturity. Actually, I love that idea because that could mean so many different things, so many different phases of the grantor's intent, things that are invisible to them, right? So the planning team does not have to predict every request. It has to identify where future discretion will matter.
Otherwise, a grantor may select a trustee based on reputation, relationship, cost, or convenience without examining whether the trustee is suited to the choices the trust will require.
The planning team should also help the grantor communicate purpose. What is the story behind the wealth? What are the risks that matter to the grantor? The opportunities the grantor hopes to create for future beneficiaries, and the reasons that the authority was allocated as it was through the trust document. Those communications must be coordinated with the governing document and applicable law, but without context, even a capable trustee may be left to infer purposes that the grantor assumed were obvious.
Yeah, and I want to touch on something. I know I've said this before. I've said it well, I've said it hundreds of times, but I've said it in our podcast especially, right? To that point, this quote that I have, right? Wealth, divorced from the wisdom that created it, is all too often wasted by those who inherit it, right? So let's make this practical. What should the wealth owner now ask before deciding between an outright inheritance or distribution and a trust? And I want to go ahead and ask you first, Dr. Matt.
Yeah, we need to make this very, very straightforward. So the first question, I think, is, what do I want this wealth to make possible in my beneficiary's life? That moves the conversation beyond just simply preventing loss of the principal or the wealth itself.
I think second is, what specific risks justify limiting the beneficiary's authority? And I would want to encourage the grantor to name the risk. Don't hide it inside general words like protection or responsibility.
Third question, which choices should the beneficiary make without another person's approval, and which are consequential enough that someone else should participate or decide?
And fourth, is the concern temporary, permanent, or impossible to predict? That answer may affect how long the trust continues and how authority can change.
Fifth question, what evidence do I have about how the proposed successor trustee will exercise discretion when the document permits more than one reasonable answer?
Yeah, and I'll just say this, and perhaps the hardest question: am I using the trust to serve the beneficiary and the purposes of the wealth, or to preserve my own control after I'm gone?
Carter, that should be asked without accusation, because control is not always improper, and there may be sound reasons to limit access and preserve assets. But unless the purpose is clear, future trustees and beneficiaries may struggle with restrictions in the document whose real rationale was never expressed.
So we've spent quite a bit of time here explaining why a trust might be appropriate. Now, when might an outright inheritance actually be the better choice? And that's a question that I think a lot of times, especially with the mass affluent demographic that we cater to through the advisor network, I think that's the one that inherently is like the most obvious thing for them whenever they're thinking about some sort of an estate plan is, well, when might an outright inheritance why isn't that already the better choice, maybe, is what they're asking.
Well, Carter, when the beneficiary is capable and the identified risks don't justify continued control, and the wealth owner intends the beneficiary to possess full ownership, that would be a situation where an outright inheritance is appropriate. The beneficiary may have demonstrated responsibility over many years, and the wealth owner may value the simplicity and autonomy more so than the protections a trust could provide.
And there is just simply dignity in allowing an adult beneficiary to govern his or her own life. Retaining authority is not always the more responsible choice. Sometimes responsibility means just simply letting go.
Yeah, that's a very valid point. And when does it make sense to retain meaningful authority in a trustee? Dr. Matt?
When the purpose of the wealth requires someone to do more than just simply transfer it. Perhaps the beneficiary lacks present capacity. Perhaps the assets need protection from external claims. Perhaps the trust must coordinate competing interests across beneficiaries or generations. Or perhaps the grantor wants the wealth applied to defined purposes over time.
But that choice carries a corresponding recognition. If you give a trustee meaningful discretion, you are not merely hiring an administrator, you are giving someone authority to affect the beneficiary's access to wealth, whether it be during illness, family conflict, financial stress, ambition, or urgent need. And the trustee may have to say yes, or the trustee may have to say no. Sometimes a trustee may have to propose an alternative that no one anticipated.
Yeah, and the grantor will not, it's post deceased, right? We're talking revocable living trust on the front end, become irrevocable on the back end, right? And the grantor, they're not going to be there to be able to referee.
And that is the title of this particular episode of the Invisible Threat podcast. The title, When Your Judgment is No Longer There, the need for judgment does not disappear. The question is, whose judgment will take its place? And what, if anything, you were able to learn about that judgment before giving that person authority?
Yeah, so we began with the familiar estate planning question. Should I leave the wealth directly to the people I care about or place it in a trust? So we can now see several questions inside of it.
That's right. So, question, who should have authority over the wealth? Another question, what purposes should guide that authority? What risks would justify limiting the beneficiary's control? And where will future discretion be required?
3 conclusions follow. First, an outright inheritance does not eliminate judgment. It places judgment with the beneficiary. Second, a trust does not preserve the grantor's judgment. It transfers future discretion to someone else, a third party, guided by the document, but never completely replaced. Third, the grantor should not transfer consequential authority and control of their wealth without meaningful visibility into how the recipient will exercise that authority and control under ambiguity.
Oh, man. So much here. So before selecting a successor trustee, the wealth owner really must answer the question that comes first. Should anyone other than the beneficiary have authority and control over the wealth? Right, Joanne?
That's right, Carter. And if the answer to that question is yes, the next question for the grantor is not simply who is willing to serve or how much they would charge in order to serve. The question is really, whose judgment am I prepared to place in that position?
And then, for the person or persons whose judgment has been selected, show me how that judgment will be exercised under ambiguity, meaning when the rules run out.
So good. So once a wealth owner decides that authority should be placed in a trust, the successor trustee selection question becomes obviously unavoidable. Should the successor trustee be someone who knows the family personally, or should it be a professional institution with experience, a documented process, objectivity, and continuity?
And Carter, a family member may understand the people, the history, and the values behind the grantor's plan, but that individual person may also face family pressure, internal conflict, limited experience in dealing with trusts, or they may be experiencing their own changes in health and availability to do the job appropriately. On the other hand, an institution may offer professional capabilities and continuity. However, that institution must still exercise discretion through actual people, policies, committees, and practices inside their institution.
And we've been in the industry for a long time, and the familiar comparison is family experience, meaning familiarity, versus institutional expertise. The usually invisible comparison is where the exercise of discretion will be most capable, durable, and faithful to the purpose of the trust. And that will be our topic for the next episode. Family member or corporate trustee, not merely who can administer the trust, but where should judgment reside.
I'm really excited about the next episode. So until then, remember the proposition at the center of this series. You are not merely deciding who will receive the gift, right? The transfer of money when wealth transfers, right? We're in the, depending on who you talk to, $84 to $124 trillion great wealth transfer over the next 2 decades. You are deciding who will receive authority over it and whose judgment is responsible to determine what happens to it next. Before you transfer that authority, make the judgment behind it visible. Until next time, keep making the invisible visible. Most estate planning processes move past these moments. We don't. I want to thank my incredible co-hosts, esteemed as they are, great friends of mine too, Dr. Matt and Joanne Eby. Thank you so much for going through this initial sort of different direction that we're headed now, more on the front end of things. We don't have a dissertation necessarily on this, but I am really excited about where this is going to take the thought process that happens well in advance that people need to consider. And I cannot wait until next week's episode. So as is always, thank you guys for, sharing your decades of experience and seeing some of these things to take into consideration.
You're welcome, Carter. It's always great to be with you. And this was a very, very well done episode between all of us, and the collaboration is just tremendous. And you can see many of the things that we've talked about over the years as we went through all the details here.
Yeah, and I can't wait to pull out more out of you, Joanne, as someone who's been an attorney, obviously, because, right, wrong, or different, it's Dr. Matt and it's attorney Joanne. You guys bring so much, I hate to use the word believability, but that's the reality of it, right? With the dissertation that you have, Dr. Matt, and obviously the years of being an attorney, you, Joanne, thank you so much for being, the sounding board that I get to pull out of that wealth of knowledge that is in both of your guys' brains.
You're welcome, Carter. And for me, it's just we're paying it forward. This is what I'm excited about.
Hey, listeners, make sure to join us for another episode, and the next one is going to be phenomenal, I can promise you, of the Invisible Threat Podcast. Make sure to like, share, and subscribe wherever you do get your podcasts. And until next time, we will see you on the Invisible Threat Podcast. Thank you, everybody.